Hello and welcome to our very first episode for the year 2025 of Inside the Courtroom, the Senzo Meyiwa murder trial. I am Linda Mnisi. So much happened at the end of last year, prompting some changes in the trial. You'd also recall the unfortunate death of Thulani Mngomezulu, that's the lawyer for accused number one, Muzi Sibiya. Sibiya now has a new lawyer in the form of Advocate Charles Mnisi, and you'll also remember that the trial ended with Advocate Zandile Mshololo still cross-examining the lead investigator, Brigadier Bongani Gininda, on the evidence brought by the state against her client. The state alleges that accused number 5, Fisoguhle Ntuli, convened all the accused in the commission of the crime. He's also alleged to have driven the getaway car on the day of the murder. State witness Constable Sizwe Zungu previously told the court that Ntuli was driving a grey VW Polo on the day Senzo Meyiwa was killed. He told the court that he saw him at the Basotho hostel in Vosloorus on the afternoon of the 26th of October 2014. This was hours before Meyiwa was killed. Now, in a bid to prove that Ntuli drove a silver grey Polo, the state, among other things, revealed that infringement notices were given to Ntuli on the 9th of February and 20th of March 2016.
And this Polo that was driven, that is alleged to have been driven in 2016, the color and its registration number, is it the same motor vehicle that is alleged to have been driven on the 26th of October 2014, when on the date of the incident?
No, my lord, we can't say with certainty because the statements insofar as the incidents of the 26th of October 2014 refers to a silver Polo and also refers to the suggestion that it may have been a hired car, but there's no specific registration number given. So based on that, we cannot say. The only similarity that it's a silver Polo and it was a car belonging to the shuttle services, but we can't say. I don't have evidence that says a specific vehicle with a specific registration number that was used on the 26th of October 2014. I don't have that, my lord. So we have similarities, but not the registration number.
Mshololo further touched on the identification of a vehicle.
And Brigadier, is it correct that the only way in law in which you can identify a motor vehicle is by its registration number?
I think the question is too broad. Yes, if we are talking about the specification, that is now wanting to link the vehicle to its manufacturer. For example, this being a VW, to say, is it indeed a VW from Volkswagen South Africa? Then you need specification. You need the registration number, you need the VIN number, you also need the engine number, because then you confirm it. You confirm the details with the manufacturer. But when you talk to the commission of crimes, cars are described all the time by the description of how they look like. It's the same with suspects. People who describe a suspect in terms of the features, not necessarily the name of the suspect. So in my understanding, the same principle applies. If a suspect or a witness says, I saw a BMW 3 Series, tinted windows, and I think that vehicle had a sticker that is a construction vehicle or it's a ACPS vehicle that was present when the offense was committed, and you happen to find a similar vehicle during the course of investigation, there are similarities, my lord. But yes, if you want to talk to specific identification, you will need the engine number, the VIN number, the chassis number, and the registration number, my lord.
She also touched on the link between the registration of a vehicle and ownership.
And with the registration number of a motor vehicle, you can be able to get the names and the ownership of that specific motor vehicle.
That is correct, my lord.
Did Constable Zungu give you the registration number for the said Polo vehicle that he identified at Basotho Hostel on the 26th of October 2014?
No, he didn't, my lord, because he didn't recall the registration number, so far as I can remember.
At the center of Gininda's testimony is the allegation that Ntuli and his co-accused executed a hit on Senzo Meyiwa that was allegedly ordered by the soccer star's then girlfriend, Kelly Khumalo. Mshololo drilled down to the banking records of her client.
From Exhibit E6, the bank records from the Netbank, wherein you read certain information into the record. Did you request the information from Nedbank covering the period of October 2014 regarding the transactions under the name of accused number 5.
Yes, my lord, I would have made that request specifically because that was the date that is relevant to this matter.
From the records that you received from Nedbank, is there or was there any transaction, or let me say, is there any transactions on this exhibit, E6, reflecting transfer of money from Ms. Kelly Khumalo to accused number 5?
My lord, my recollection, and not only with regard to accused number 5, but insofar as all accused and from all institutions, not only Nedbank, there is no electronic transfer from Ms. Kelly Khumalo to any of the accused. That we did not find.
According to the state, Ntuli is alleged to have links with Kelly Khumalo through calls that happened twice before Senzo Meyiwa was murdered. The state said calls were made on the 2nd of August and 15 October 2014. The latter was just 11 days before Meyiwa was killed. Ntuli denied ever making contact with the singer.
Did you request the bank transactions covering that period of 2 August or 15 October?
My lord, I don't have a recollection, but one will have to check because the record starts in 2014. So I don't have a specific recollection of whether when I requested this document, I started at the beginning of 2014 to date or what. So if perhaps then one will need to ask the court's indulgence that perhaps during the long adjournment, then I can check the application in terms of the date. I may have covered it, but I'm not sure, my lord.
Mshololo going to the link of parties in a banking transaction.
I know you've already said you're not sure whether you have records for these 2 periods, but on the other transactions contained in exhibits E6 and 8, if a person deposits the money to someone else, and then how would you connect, how would you link that transaction? Is it not by account numbers of the 2 respective parties?
My lord, my understanding, you will establish the link that is firstly in terms of the accounts. If the money is transferred from one account, transferred, not cash deposit, to another, because then you are able to identify the account number, and obviously you can get the details of the account holder in the B section, and then subsequently say A, and then moved to the person who received it. So that is the first point, my lord. When it's a cash deposit, my lord, you will establish the link only if the person who makes the deposit makes a specific reference, because they can put anything, anything. They can put my name, they can put whatever reference that they put. So all you will have is where the money is going to, but the depositor, it depends what the depositor put. What you'll be able to prove is that the recipient received that X amount through the bank or ATM deposit, my lord. And my understanding, my lord, this is under the normal course of bank transactions. It differs then when there are criminal activities taking place, because people then will want to conceal the identity of what they are doing, be it money laundering or any form of criminality. So the first 2 examples I've made are insofar as normal bank transactions when you do investigation in that regard. But then when such transactions, banks are used for criminal activities, then the picture changes completely, because I don't think any criminal, my lord, will just put his details and say, or suspect and say, me, I'm depositing this money for someone to be killed, or I'm depositing this money for someone. That you will not find, my lord.
Mshololo tackled the issue of payment for the alleged hit on Meyiwa.
Also, just for the sake of clarity, Brigadier, in respect of this case, there is no cash deposit that was transferred in either of these exhibits, in either of these bank records for accused number 5 from Ms. Kelly Khumalo to accused number 5.
Yes, that's true, my lord. But what we have on the investigation, at least the transactions that we can prove, is that money was paid in cash at Basutino Hostel on the day of the incident. We can account for some payments there in cash, and a later amount, as I've indicated in my last testimony, of 30,000. That was paid specifically to, by accused number 5 to accused number 2. That is now, you'll find that in the exhibit HH and JJ. I covered that aspect. But it was cash transaction. There's no evidence that we found.
No, Colonel, I'm referring to these exhibits. Triple E, we are on Triple E.
Yes, can I just finish, my lord? Because remember, can I just finish? Because these exhibits, the question that I'm being asked is in relation to this offense in general. We don't have evidence or any suggestion in the docket that says the money was transferred by Ms. Kelly Khumalo to any of the accused. What we have when it comes to the monies that comes to existence after the deceased was shot, my lord, is that money was paid in cash. That is what we can put our hands on, my lord.
One of the key pieces of evidence implicating Kelly Khumalo in the alleged hit is the alleged confession statements of accused number 1 and 2, Muzi Sibia and Bongani Gininda.
Besides the information that is contained in those 2 confession statements, is there any other independent information relating to the instruction which is alleged to have been given by Ms. Kelly Khumalo?
My lord, if the question is to say was there a witness present when the instruction was given by Ms. Kelly Khumalo to the accused, we don't have that witness, my lord. If perhaps that's what Advocate Mchololo is asking me.
No, I'm not specific to say is there any witness to that effect. I said, is there any other independent evidence relating to the instruction which is alleged to have been given by Ms. Kelly Khumalo, other than the information contained in the 2 statements?
My lord, what you have corroborating evidence, because you have this assertion made, then you have, for example, the statement of Zungu, Mr. Zungu, who is a police officer, who narrates what happened on that day and corroborate or say things that seems to corroborate what is contained in those statements. You have the statement of Simpiwe Sifiso Zungu Kwabeni, who says certain things insofar as what happened prior to that deceased being killed. In other words, all the 5 accused meeting at Basutini Hostel, departing, coming back, accused 1 announcing that now have they heard that Senzo Meyiwa has been killed. And I've testified about this, my lord, that at this stage, it was before even the media covered the killing of the deceased. So and then you have Simpiwe Buthelezi, who implicates accused, I think 3 and 4, about their involvement in this matter. Simpiwe Buthelezi. So if you take, and this is now independent from the confessions, my lord, so if you take the confessions coupled with corroboration of what happened, what witnesses saw, and those whom the accused or some of the accused spoke to, if you take them into a totality, my lord, as a collaboration, it does create an impression that indeed this would have been a contractual killing. Because in my investigation, my lord, I found no evidence that suggests that any of these accused had a quarrel or anger or hatred with the deceased. They were not even in the same profession, so there is no reason that they would have been in conflict with the deceased, my lord.
Advocate Zandile Mshololo wrapped up her cross-examination, but you'll remember that Advocate Charles Mnisi had requested some documents from Gininda regarding some of the evidence presented in court. Now, after the break, we get into questions posed to Gininda by Mnisi on those aspects. Stay tuned. Advocate Mnisi had previously requested warning statements and further information on Mjiako. This is now Ntanzi's disputed lawyer who allegedly represented him when he deposed his second confession statement before Magistrate Grenier. Gininda referred to a number of statements that he obtained during his investigation, and one of those is the statement of the late Simpiwe Buthelezi. This is the statement that Advocate Mnisi started with when picking up on some of the questions he posed to Gininda.
Accused number 3, Mr. Mnube, requests me to tell you that we are not making a mistake. You're not making a mistake. When you told this court that Simpiwe Buthelezi and accused number 3 knew each other, he says it is indeed so, because they are from the same area. They are from the same area, however, in the larger area of KwaNongoma. I think that you will welcome, you say no, that's true.
Well, it is true, my lord, because in the statement of Simpiwe Memela, that's what he says. He says he knows accused 3 and 4, but specifically says he is closer, or rather he was closer to accused number 3. So the statement of the deceased, now being Mr. Buthelezi, says that as well, my lord. So I think we're in agreement.
In his statement, Buthelezi alleged that accused number 2, Bongani Gininda, was a well-known gun supplier prior to his arrest. He's also alleged to have assisted the police in tracing Gininda.
This person knows that Simpiwe Buthelezi had been serving a sentence in a jail at KZN. That when he was serving, he got afflicted mentally, and then they had to place him on a mental parole. While so serving his sentence at home as a result of that fact that he was released on a mental condition, a team of investigators then arrived where Simpiwe Buthelezi was staying, including yourself. And indeed, you wanted to have a conversation with him. However, due to the fact that you could observe, when I say you, I mean the collective, the police, they could observe that his understanding of issues mentally was challenged. You then requested this person that I am referring to as either a they, he or she, to accompany him with you to Pretoria, where you were to come and take his statement. But then the team that was led by you then decided to buy a cell phone for this Simpiwe Buthelezi. For whatever reason, this person will not know. This person knew Simpiwe very well.
Gininda says it's untrue that he was there when the statement was obtained.
Firstly, my lord, it is not true, and I can put it strongly to say it's a lie, that I went to Simpiwe Buthelezi's house. I don't know it, standing here today. Not that day when he was picked up, no, even after we were trying to obtain the death certificate. So I do not know his home residence, and I was not part of that. Secondly, my lord, with greatest respect as well, my lord, it defies logic to me in saying you find a person in KZN whom you can see is not in a good state, health-wise, mentally. And the only reason you want to engage with this person is to take a statement, but you decide to actually drive this person all the way from KZN to Pretoria to do the same exercise. Why not take a statement in KZN? My engagement with Mr. Buthelezi, my lord, resulted in this affidavit. And this affidavit, which is A158, that's the one we're referring to, collaborates, as I've said, the part that implicates accused number 3 and 4. Now, what will be the purpose of giving him a phone, let alone the illegalities of it? What will be the purpose? Because after this statement was given to me, my lord, there was no other reason or engagement I had with him. He collaborated this part, the statement was filed in the docket. All that we were waiting for was for him to consult with the state as and when the matter presumed. There was no further engagement from me. Further, my lord, and it's something that I can, if advocate needs me to pursue it so that we can deal with facts, I'm prepared to do that, to approach the state correctional services that is referring to and really establish as to whether this person was released on parole due to mental conditions, because I've never had such. My understanding is that if a person, if that had to be the case, because of the mental condition, he would have been referred to the mental institution. I've never had a government department throwing someone on the street who is not mental okay, because in essence, that's what it means. He's incarcerated, there's mental problems with him, and then he's then released to get what medical attention, my lord. I've not heard of this. And that is why I'm saying with greatest respect, perhaps, because this is his instruction, it's what is being told. We can, and I'm willing to do that, to pursue this correctional center and really find the records, because the records should state that indeed he was released for mental condition. But I doubt very much, and I must say that with greatest respect. All I can say, my lord, is that when I engaged him, I did not see any signs of him being mentally disturbed. We spoke to each other, and indeed, Mr. Mnisi confirmed that he knows accused number 3, in particular because what Advocate Mnisi said about accused 3 with Mr. Simpwe Buthelezi, it's what the same person says, that I know accused 2, 3, and 4, but I'm more closer to accused number 3. And in this statement, he says, we come from the same area in Wanongoma. So how could this person be mentally disturbed? Because I didn't know him, my lord. So this information came only from the deponent of this statement, because this assertion was not told to me at that stage. The only person who told me this, which is now confirmed by accused number 3, is the deponent. If this person was mentally disturbed, how did he know this information, my lord? Lastly, my lord, if you read this statement, this A158, one will see, if it was to be read on record, my lord, that this person was on his clear senses and sober senses, my lord. That's the impression I got. I didn't get any other impression until this statement was concluded. And if you read what he says, my lord, it's of a sound mind person. Only sound mind person can dispose, in my view, in my observation, and I'm talking to the experience that Advocate Mnisi referred to. So I did not get this assertion that he was now mentally disturbed, my lord. Lastly, my lord, the last aspect, perhaps I think it's important because it also relates to the cell phone. If one look at the preamble, this is now paragraph 1 of his statement, he gives his cell phone number. So meaning he had a cell phone, my lord. And I'm talking to this issue that he was now given a phone, bought a phone. If you read his statement, the first part where he identifies himself, he mentions a specific number as his cell phone number.
Mnisi also touched on the identification of his client.
Now, he requests me to put to you that he since he was born, he never had a dark complexion. He always had a light skin complexion as he is looking now.
My lord, I will not be able to dispute how it looked like when he was born, because obviously I don't have direct knowledge or sight of that. However, what I can say is insofar as the photos that we went through, and we did that exercise with Advocate Mnisi, and in those photos, or rather in some of those photos, you can see that accused 3 is not bearing the same complexion that he has now. And I even narrated when I was referring to the complexion of dark brown that is contained in Steenkamp's affidavit, that it fits the description of his complexion then in 2014. And I did indicate, my lord, that yes, he is much lighter now. There's no mistake about it. But if you look at the photos of 2014, and I even said in some photos, his complexion is the same as the one of accused, I think 4 or even 5, if you look at them according to the pictures. So as to how he was born, my lord, I don't have direct knowledge. But how he looked like on the downloads that were found on his phone in 2014, he definitely didn't look like this. He was much darker, my lord.
He also took Gininda up on the golden insert description that he says was given by witnesses in their statement.
So what I wanted to say, my lord, is that as much as we have the medical results from which I've indicated what they say in my recollection, in the docket or the investigation, there is no evidence that says the incision, either by the first intruder or the second intruder, was medically inserted. So I just want to qualify that it does not mean we have evidence that the first intruder was taken to a medical practitioner and the gold teeth was medically inserted. So it could have been an artificial one that could have been removed. So I just wanted to qualify that we thought, obviously these are done medically. Let us see what the medical examiner will find. But the absence of the finding does not mean it did not exist in either of the people that were seen, my lord. That's all I needed to say.
Okay, Dr. Gininda.
Advocate Mnisi has previously argued that Gininda was supposed to have used a warning statement when he engaged with Ntanzi the first time he met him. This prompted him to request Gininda to bring the different warning statements to him in court. After going through the different statements, Mnisi sought to know who had given them to Gininda, but also that he was wrong on his assertion that there was not a prescribed form that ought to be used.
Your version that there's no authority that prescribes a certain which form must be used when a statement is taken from a suspect within the context of the South African Police Services.
No, I disagree, my lord. I'm sitting with a statement from Brigadier Gininda right in front of me, and I can read it to the court. He is from the policy, the head policy in the component governance, legislation and policy in the Division of Legal Services of the South African Police. He made this statement, and there's no authority, there's no section or standing order that he says this. I can read the statement into the docket. So if I'm being told there is an authority, I don't know where it's coming from, because this brigadier is from the policy division of the South African Police, and he says there's no policy that prescribes a specific form. It's a statement under oath.
Mnisi referred to a book called Iqabane, written by police officers, which he says details standing orders for police officers. Gininda says, although he knows some of the authors, he does not know the book, and reiterated that the head of policy in the SAPS deposed a statement saying there is no specific authority on the use of a particular warning statement. Mnisi wrapped up his cross-examination on behalf of accused number 3, that's his client, Mtobisi Mncube, and was due to start with his cross-examination on behalf of accused number 1 when he requested nearly 2 weeks to go through the record. You remember he's been appointed as the lawyer for accused number 1 after Thulani Mngomezulu sadly passed away at the end of last year. After the break, we get some legal analysis from our legal analyst, Melusi Xulu. Stay tuned. Welcome back. Let's get some legal analysis now, and I'm joined by legal analyst Melusi Xulu. Melusi, thank you so much for your time. You and I have spoken extensively on the description of suspects in a criminal trial, but now we're hearing of descriptions of the alleged getaway vehicle. Would you say that the same legal principles or the same approach is taken when looking at perhaps the description of some of the things that may have been used in the alleged crime?
Yes, Linda, I think what is important is if there was a certain getaway car that was used and is linked to one of the accused, it obviously bolsters or assists the state's case to be stronger. For instance, if we know that Mr. Nduli, for example, was driving a certain model with a specific registration number, that assists to say that motor vehicle was used by him, and it assists for evidence, for the state's case. However, I will have a problem if it's just a motor vehicle that is not known by any of the people who could say it belongs to one of the accused, or if there's no registration number that can link them to any of the accused. So I think what is important about the motor vehicle is who does it belong to. I think that's where we need to start. But if there's nothing beyond that, it doesn't help the state.
One of the things that Advocate Mshololo was asking is that by law, the issue of the registration of the vehicle would assist in determining who the owner of that particular vehicle is. But also, when you look at the descriptions that have been given, none of the people, as conceded by Brigadier Bongani Gininda, could take down or could recall the registration of that particular vehicle. The only description that was given was that it was a grey Polo and that he was allegedly driving it or came with it to the hostel.
I don't think it assists to have such a motor vehicle that being stated that it's a getaway car, but there's no registration, there's no linkage to any of the accused. So I think with the brigadier as conceding to that, it shows that it's not taking the state's case anyway with regards to the specifics of a getaway car.
How important is this getaway car in the state's case, given that, the allegations are that they must have traveled to the particular location and left the location? So how important is it to prove that, in fact, there was a getaway car?
Look, you get some cases sometimes where the getaway car, you'll find that the accused who were sent or contracted to kill someone or assassinate someone are caught the same time with the motor vehicle, when they've just finished the deed, so to speak. So sometimes it assists to know what car were they driving, what was the registration number, and then it can link the accused to that particular getaway car. But if it doesn't have anything, I mean, I don't think it will take the state's case anywhere. I know I keep repeating this, but it doesn't help anyone to say there was a car, a polo car, silver gray, but no registration number. So it's just to show that, well, there is evidence, so to speak, that there was a getaway car, but